Welcome to everybody to today's seminar, hosted by the Health Law and Ethics Network and the Centre for Comparative Constitutional Studies here at Melbourne Law School. I'm Associate Professor Paula O'Brien. I'm one of the directors of the Health Law and Ethics Network, and I really warmly welcome you to today's event. I acknowledge that we meet on the lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past, present and emerging. And I acknowledge that this land was never ceded by First Nations peoples. We're very pleased to welcome Irene Carlet and Bill Madden today to present this seminar. So it's a comparative look at no-fault compensation schemes for vaccination harm in Australia, Italy and Germany. So we're really so pleased that we could bring together Bill and Irene. So Irene is a visiting PhD student here at Melbourne Law School. She comes to us from the Max Planck Institute for social law and social policy in Munich. And it's been wonderful to have you here for the past 3 months. Irene's PhD is on no-fault compensation schemes. So she's such an expert and bringing so much expertise today. We're also very pleased to welcome Bill Madden, who is a senior fellow at Melbourne Law School. Bill is here right at the moment teaching medical litigation in our master's program, and I welcome some of his students here today. Bill is a very important part of our law school and a very important part of our master's program. Bill is a very well-known practitioner in the area of medical litigation. He's an author of various textbooks, and he runs a fabulous blog as well that's called Bill Madden's WordPress.com if you're interested in following up. So we're going to hear from Bill and Irene for about 20 minutes each, and then we'll have some time for question and answer as well. We're welcoming quite a few people online, so in the Q&A we'll both hear from people in the room, and I'll also try and draw questions in from people who are online. So thank you very much for joining us. I'd like to welcome Irene. Thank you.
Thank you very much, Paula, and thank you everybody for being here. So I would also like to begin by acknowledging the traditional owners of the land in which we and pay my respect to their elders past and present. We will soon explore vaccine no-fault compensation in Germany, Italy and Australia. But let's first frame the comparison with a fundamental question. This question relates to the level of reciprocity and solidarity that it is politically, ethically, and constitutionally required of the legal system. During the pandemic, I was saying the rush to the COVID-19 vaccine and the major interest at stake prompted in many countries the adoption of new no-fault scheme or the extension of existing ones. But interestingly, beyond the pandemic, there are several considerations and arguments to have these schemes in place. Politically, these instruments are desirable in order to enhance public confidence and promote the uptake, but mostly they are helpful in order to support research and development, mainly by protecting manufacturers from liability. Ethically, there is a strong argument as well. It is widely recognized that immunization is a public good and that the act of receiving vaccination is a service that the individual pays to the community. In light of this, there is a reciprocal link in between the community and the individual, and the community would owe that of gratitude towards the individual. From a legal perspective, even though vaccines are safe and effective, the occurrence of, well, albeit rarely, the occurrence of serious adverse reactions following vaccination poses concerns of distributive justice. This calls for legal system to set a reasonable balance in between the individual and the public health. And interestingly, this type of constitutional arguments lay the ground to the adoption of no-fault compensation schemes in both Germany and Italy. In Germany, we have the theory of sacrifice. This is mainly codified in this Act on the Protection Against Infectious Disease that traces back its origin to a landmark judgment of the Federal Supreme Court of 1953. The case concerned a claimant who at the age of 1 received vaccination against the smallpox and after that suffered severe health impairment. There was no fault on the part of the practitioner who administered vaccination in this case. So at a time when no special regime was in place, the only way to recover damages was through establishing state liability. The court did so by adopting an extensive interpretation of the old doctrine that had developed under customary law in relation to expropriation and encroachment of property. The reasoning of the court leveraged the fundamental right to physical integrity that is enshrined in the Constitution. And substantially, the court said that just as like in case of damages to property rights, when there is a damage to individual health caused by the vaccination through no fault of one, the community must bear the relevant costs. This is because the vaccination damages is a sacrifice that the individual makes for the community, for the common good. And for this, the individual qualifies as a victim. This first judgment was adopted in the context of mandatory smallpox vaccination, but a subsequent judgment then extended compensation to recommended vaccinations, holding that there is no reasonable differentiation in between a mandate and a recommendation, when the recommendation is such as to exercise a psychological influence, so that basically parents are persuaded, convinced that they cannot avoid the recommendation in light of a conscience bond that they feel. Very similarly to this development in Italy, against the background of the constitutional legitimacy of mandatory vaccination, the Constitutional Court back in the 90s established that it is necessary to provide equitable compensation to individuals who suffered harm following vaccination, and that this would follow the need to set a reasonable balance in between the individual fundamental right to health and the major interest of the collectivity in health. In response to this judgment, in 1992, the statutory scheme was adopted, granting compensation to anyone who had suffered a permanent impairment of their psychophysical integrity. But the wording of the law limits the scope of the scheme to mandatory vaccination. Yet the Constitutional Court's judgment after judgment extended the scope of the scheme to certain recommended vaccination, and the requirement is that they are strongly recommended. We will see now what this means. Indeed, the court developed a theory and clarified that first, the right to compensation is rooted in a principle of social solidarity. The Constitution enshrines fundamental duties of political, economic, and social solidarity that individuals must fulfill. So the idea of theory developed is that when the individual receives vaccination, is fulfilling a fundamental duty of social solidarity. As a result, the community is bound by this duty to the individual. And the point is that withholding compensation to an individual who suffered harm after vaccination would be contrary to a principle of justice. And even more, it would be irrational to compensate those who were compelled by law to vaccinate, while refusing compensation to those who vaccinated voluntarily out of consideration of social solidarity. More recently, in 2020, the court law clarified that in order to extend compensation to encompass strongly recommended vaccination, it is necessary a prior submission to the Constitutional Court that must assess whether the vaccine campaign was such as to exercise, to instill in citizens a sense of duty towards safeguarding public health. From a practical perspective, there is a common aspect. It is extremely difficult to recover damages in civil liability litigation. Under the product liability regime, indeed, claimant faces two main obstacles. One is the proof of the effectiveness of the vaccine, and the second one is, of course, the proof of causation. Another litigation strategy could be to sue the the doctor who administered vaccination for claiming alleging improper administration of a non-defective vaccine. Even in this case, though, the burden of proof is quite high. And one argument could be that a doctor failed to provide complete information about side effects. But medical practice relies on standard form that normally include comprehensive information. Moreover, in some individual cases, albeit rare, non-defective vaccines, so vaccines that do not present any defect of manufacture or design and that are properly administered, still produce idiosyncratic reactions. And especially in these cases, it seems that no fault compensation is the only way forward. So given the shortcomings of civil liability litigation, in practice, both in Germany and in Italy, these type of claims are filed under the special regimes. We are coming now to the German fault compensation schemes, and these graphics compares the reports of non-serious in the blue columns and serious adverse reactions following vaccinations in the period from 2019 up to 2021. The Paul Ehrlich Institute, which is the federal institute responsible for surveillance on vaccines and reports to the Federal Ministry of Health, received 471 suspected cases of permanent damages, but could identify a causal link with vaccination in only 17 cases. In all other cases, no connection was found with vaccine. We are looking at the data on surveillance because there is no central database in Germany when it comes to the number of compensation applications. And this is something that applies also for Italy, as we will see later. This is the German National Immunization Schedule, which identifies the vaccinations that are publicly recommended. We should note that since March 2020, vaccination against measles became mandatory for children in access, nursery and schools. And we are now going to unpack the main features of the German fault compensation schemes. First of all, as already explained, the vaccines covered are those that are mandatory and those that are publicly recommended by the competent authority of the lender, which though follow the recommendation of the federal independent advisory body that is competent, and it is the Standing Committee on Vaccination. The injuries that are compensable are the health and economic consequences of the vaccination damage that goes beyond the usual extent of a vaccination reaction. And the people that can claim compensation under the scheme are, well, the injured vaccine recipients or the surviving dependents in case of death of the vaccine recipients, or non-vaccinated people that have been harmed as a consequence of contact with the vaccinated person. This normally happens through transmission of living pathogenic agents. Causation is interesting and actually deserves a couple of comments. In 1971, statutory reform introduced mitigation of the burden of proof and a special hardship rule. So a claimant under the scheme must fully prove three things: the actual vaccination, the unusual reaction, and the adverse consequences, but must only prove reasonable likelihood of causation in between them. What does this mean? Courts decide that causation exists when, under consideration of the leading medical opinion, it is more likely than not that the vaccine was the cause of the damage. The court has to consider, when they look for the leading medical opinion, the state of the scientific knowledge at a time when the decision is taken, and they must make sure that there is no equally likely alternative cause that otherwise would exclude causation. In practice, there are two crucial considerations for this causation assessment. One is whether, and apologies for my oxymoron, is whether the unusual reaction falls within the typical complications that are described by the Standing Committee on Vaccination. And secondly, whether the time frame is also consistent with what is described by the leading medical opinion. The hardship rule finally might come into play when there is remaining uncertainty as to the origin of the medical condition. Indeed, it applies when the insufficient likelihood of causation is due to insufficient scientific knowledge. And in these cases, courts actually require the existence of at least a minority medical opinion. The successful claimant is granted, well, a pension for the inability to work further, but also, and very interestingly, sickness benefits, funeral benefits, and medical treatments. The quantification, though, is made on a singular basis following the guidelines that are applicable under social compensation law. The relevant procedure is an administrative one. The claim must be filed with the local social affairs offices of the land. Their decision can be challenged before the social courts. One critical aspect that commentators have observed is that the length of the procedures when a case goes through all of the three instances can be a cause of distress for claimants. And a final, actually interesting aspect, distinctive aspect of the German scheme is that by virtue of its design, as we have already described, it was already extended since the origin of vaccinations. The scheme was able actually to encompass COVID-19 vaccines since the beginning of the vaccine campaign in Germany. We are now coming to the Italian scheme, and we are starting as well with the surveillance on vaccination data. And this graphic, which is from the Italian Medicines Agency, shows and compares the overall number of reports for all of the adverse reactions following vaccination with the reports concerning serious adverse reactions that can actually be linked to vaccination. And I think it is interesting to observe two things. One is that, as we can see, the overall number significantly increased in 2021 for quite obvious reasons. At the same time, though, this is not true for the number of serious adverse reactions that can be linked to vaccination, that comparatively still is quite low. This is the Italian national immunization schedule, and well, you can just know that all of these vaccinations are mandatory, except for those that I have marked with this little r, that these are those that are recommended. And looking at this is actually helpful to get an idea of what are the vaccinations that are covered under the scheme. Again, as we have already discussed going through the constitutional case law, mandatory vaccinations are covered, and with limitation, the recommended vaccinations, those that, in those cases when the Constitutional Court has so decided, because as clarified, the principle is that there is no reasonable difference as long as though the recommendation is strong enough to instill that sense of duty in citizens, and that role, that type of assessment up to now is for the Constitutional Court. The injuries that can be compensated are the permanent impairment of the psychophysical integrity of the claimant, and well, though again, injured vaccine recipient or the surviving family members in case of death of the recipients, or again, non-vaccinated people who have been permanently impaired as a result of contact with a vaccinated person can claim compensation under the scheme. Causation in Italy is also interpreted judicially, but according to a criterion of reasonable scientific probability. Again, looking at the practice, normally courts decide on a preponderance of evidences and establish that causation is consistent when it is more likely than not that the vaccine was the cause. However, there are different decisions of courts supported by some scholars in favor of mitigation of the burden of proof. And the idea would be that under the scheme, a less stringent assessment of causation would be necessary in light of the special solidarity function that the measure performs. The successful claimant is granted, first of all, a lifelong measure of support that is quantified by reference to 8 categories that correspond to the severity of the injury. And we can note that for this year, the monthly sum ranges in between roughly 850 to 950 euros. But a second piece of legislation that was actually subsequently adopted grants an additional monthly living allowance that is going to be split in between the injured person and the relevant carers. In this case, the amount is from 4 to 6 times what is granted under the first measure of support. This second measure was adopted actually to respond to the demands of the Constitutional Court that was warning that this measure must actually be an equitable compensation and not purely trivial. The procedure, even in this case, is an administrative one. The claims must be filed with the local healthcare organizations. Experts committee to decide on compensation and on the category of injury that is going to be applied in the case. Their decision can be challenged either through a hierarchical appeal to the Ministry of Health or before the civil courts. Very recently, on the last week of March, the Constitutional Court established that the right to compensation is time barred in 3 years from the moment when the claimant had knowledge of the eligibility of the compensation to damage. And another final aspect that is important to observe for the Italian scheme is that the scheme now encompasses damages that arose following vaccine against COVID. But this was not true since the beginning. The scheme was explicitly extended in late January 2022. And this was actually a necessary intervention of the government in order to rectify a situation that was unconstitutional. Because before the intervention, only people that were within the categories for which COVID-19 vaccination was mandatory, and this means healthcare professionals and later on people over the age of 50, could actually apply for compensation. But for all other injured parties, a prior submission to the Constitutional Court would have been necessary. Now, it's clear that even the extensive campaign that was adopted and the quasi-coercive measures that were put in place to fight the pandemic, most certainly the Constitutional Court would have expanded the scheme and would have reverted the situation. So I would like now just to thank you and to leave the floor to Bill Madden, who will discuss with you the Australian scheme.
Afternoon, everyone. The approach, I suppose, or the material that I can cover in relation to the Australian slides, Australian scheme, is a lot narrower than the sort of options that have existed and been described by Irene. And it might be best if I just sort of step through and you'll see why that is, because before this scheme came into existence in Australia, there was no other vaccine compensation scheme available. And it was announced at a time when there seemed to be a political concern that medical practitioners would be sued. And there was a lot of lobbying on the part of medical practitioners to essentially support their indemnity funds. I should have brought my glass of water. I still my glass of water. I've been talking too much this morning. And there was a bit of media about that, and some clever journalists then said, well, does this mean it's a scheme for patients who are affected by vaccine adverse outcomes? And there seemed to be a long silence. And then about a week later, there was the announcement of a scheme for patients. It's not really a court scheme at all. It's a scheme made under an existing statutory piece of legislation called the Financial Framework Supplementary Powers Regulation. So it's very much subsidiary legislation that was brought into existence. And it was brought into existence with a view to it being a closed period scheme during a period, as it shows on the slide, of the biosecurity, human biosecurity emergency declaration, which only had a limited time frame. And in fact, the actual declaration is now ticking down. And so this scheme, although it still exists, unless it's changed in some way, will stop in about 12 months' time. Now, obviously, people getting vaccines won't stop in 12 months' time, but the scheme at the moment looks like it will. It's a fairly simple sort of vehicle, although there's a lot buried in that document. there's a definition of a COVID-19 vaccine, and it's essentially a vaccine which has been approved for use in Australia. And a lot of these, a lot of the scheme operation focuses on the Australian situation. So, for example, someone who may have had a vaccine in China and come into Australia would not necessarily be entitled to claim under the Australian scheme unless perhaps they have in fact used the Australian vaccine overseas. And the scheme takes two broad approaches, one in relation to vaccine-related harm, which, as you can imagine, is something substantial. And then the other is this idea of a secondary type of harm, vaccine administration-related harm. There is a definition, which you can try and quickly read through on the screen there, but essentially you're talking about harm caused by the vaccine or the vaccine administration, but there is a tendency to sort of focus on recognised complications of the existing vaccines that are around. So AstraZeneca, there was the thrombocytopenia condition. Pfizer, there were the myocarditis type conditions, those sorts of things. So you need to fit within the columns, generally speaking, and if you don't fit within those categories, you've got a bigger challenge in trying to identify the types of things that you might be entitled to claim under the scheme for. Now, with apologies for the abbreviations, you can get the general drift of those 7 conditions and the various vaccines which at the time this particular slide was put together were associated with AstraZeneca, Pfizer, Moderna, Novavax, which were the main ones that were available at the time. I don't want to spend any time on vaccine administration harm because it's a relatively minor issue, but I did want to mention that there is buried in amongst this some concern that if medical practitioners have not been doing the right thing in terms of administration of vaccines or giving advice about that, they can be referred to the Australian Health Practitioner Regulatory Authority. And part of the reason for that, I suppose, is a lot of this sort of thing is happening behind closed doors. These are government departments processing these sorts of applications. Unlike the examples that Irene gave, there is no court as such, and there are no published decisions as such. The scheme itself is, in some ways, is reasonably generous for people who have significant injury. And you'll see that there are tiers that are available, and there's an online form, and you fill in a medical report, all that sort of thing can be done. And there have been complaints that the reports need to be fairly detailed, but they're probably not impossible. And there are individuals who work for the Commonwealth Government who assess the schemes, and there are expert panels within that organisation. The main way the compensation works is, if we're talking about someone who has had an injury that has survived, is very similar to the way compensation is provided in New South Wales under the Civil Liability Act. So there's an amount for pain and suffering, which is capped under the scheme at about $693,000 per individual. There's, unlike in New South Wales, you can get compensation even down the bottom end of the scale for a modest amount of money. There's the potential for recovery of loss of earnings, but capped at 3 times average weekly earnings. There may be difficulties in circumstances where people were actually not working at the time they had the vaccine. So if they were unemployed, if they were on maternity leave, that might give rise to difficulty. The other main area of compensation is the funding for what's described as attendant care. So assistance around the house or of a semi-nursing type nature to help someone. In the event that a person has died, then dependents can bring a claim, and you'll see on the slide that there's a dependent lump sum, up to about $644,000, with some allowances for additional dependent children in some circumstances, funeral expenses of about $15,000. The legal practitioners in the room will note down in the bottom corner that there is no provision for payment of legal fees. All the lawyers are very disappointed about that. There is, within the operation of the scheme, obviously an initial assessment of it, but there is scope for a review if someone's dissatisfied with an original assessment under the scheme. And you'll see there that there's a decision maker who's basically a more senior public servant than the person who would originally have made the decision. The legislation that provides for judicial review in Australia, which can be narrow at the best of times, doesn't appear to apply here at all because of an exclusion under the Act. So there doesn't appear to be any external revision available by the Administrative Appeals Tribunal, for example. There's a settlement deed in the event that people ultimately reach an agreement so as to bring the claim to an end. And that, I suppose, in a way, may envisage or encourage some sort of lump sum agreement for past future compensation. So rather than sort of just keep coming back to us every year for the next 20 years, the idea seems to be that an agreement will be reached which will control the payment and deal with the payment and bring it to an end under a deed. There is scope under the Australian scheme for people to be compensated elsewhere. So if, for example, there really was a situation, unlike the situation where Irene was talking about, where a medical practitioner had been negligent in the administration of a vaccine and could be successfully sued, not an easy thing to do, but let's assume that it's possible, then there's not going to be double compensation. There would be a need to repay the scheme if the compensation was received in that way. There are some data that's available on the scheme website, and there's been some data published in a newspaper in Sydney late last year. And I just thought it was worth giving you a feel for what that data looks like. In November of last year, according to the Sydney Morning Herald, there had been about 3,000 claims made. But of those, only 263 had been determined. And there were others where they were waiting on additional information, a number have been withdrawn. Now, when you go a little bit further forward, that is, I suppose, in a way, criticised in the newspaper by the journalist as some sort of terrible backlog, and there are a number of people waiting to have their claims processed. But I must admit I have a suspicion that what that really is going to reflect in the longer term is that a lot of people will not, in fact, be able to make claims under the scheme successfully. That there will only be a relatively small amount of people who will succeed in claims under the scheme, just because of the very narrow focus on the conditions which we're trying to provide compensation for, most of which are very serious conditions. And you'll see here, therefore, that since the scheme had begun making payments, there have been 126 claims paid. Remember, before 3,000 applications, but 126 claims paid. However, look at the amount of money, $7.2 million. So those people who are succeeding in obtaining compensation under the scheme are getting a very significant amount of money. Having said that, it's a lot less than the amount which the government was originally concerned it might have to budget for. So the actual number of serious adverse events from the vaccine seems to be lower than was expected. The budgeted amount was 10 times that. But there are still claims in the system. The main thing which I suppose Irene and I would sort of talk about with some interest, given the difference between the scheme in Australia and the schemes overseas, is perhaps two things. Firstly, This is a scheme for COVID-19 vaccinations in Australia and nothing else. And it's about to stop at the end of that time. And the government has not made clear exactly how they will deal with ongoing vaccines past the end of the biosecurity period. None of these vaccines, unlike the vaccines I was talking about, were ever compulsory as such. They were strongly encouraged. There were some people certainly who could not work in certain areas if they did not get the vaccine, but there have been no compulsory vaccines in Australia at all. But the scheme looks like it will wind down. The Royal Australian College of General Practitioners has suggested that the scheme, in fact, should be extended to cover other vaccines which might cause adverse injuries, but which are in the public interest for people to have. Childhood vaccines and those sorts of things which we talked about by Irene. And it's very difficult to disagree with that as a matter of principle. All you can say perhaps is that there is a fallback scheme in Australia under the National Disability Insurance Scheme. If someone has a catastrophic reaction to a vaccine, they're entitled to join that other scheme. It's not a vaccine scheme, it covers all sorts of people, but that scheme is there and available to them in some circumstance. I think that sort of brings us to the end of those slides. I wanted to thank Tina Coburn, who's actually in the audience, because she and I put these slides together some time ago and I've modified them, and now I've taken all the credit for them. Thank you.
Well, thank you both very much. We have some time for questions, and what I'll try and do is move between questions in the room and questions online as well. So take that down a moment. Yes, would you like to say your name and who you are and then ask a question? Thanks.
Good afternoon. My name is Natasha. I'm a master's student at the law school. My question is to Irene. Well, I have two. The first one is sort of on the legal side. In that you said that, in terms of civil liability, and you were on the German example at that time, you said that the liability is difficult to get compensation. So I was wondering if you could shed some light on what those difficulties are from a practical perspective, of why the litigant, or rather what challenges the litigant face in order to get that compensation. And the second is not really a legal question, it's just out of curiosity. For my limited understanding of how vaccine trials and actual vaccination, clinical trials, etc., how they work, are somehow running wrong. I think that when clinical trials are done, when vaccines are developed by a pharma company, etc., clinical trials are focused on a particular gene type, maybe, I may be wrong. So in your study or your research, would you agree to that, or that is completely not true? Because the sample size that a pharma company or vaccine developer would chalk out, that I'm going to test my vaccine on so and so people before it's actually let out for vaccination to the public. So in terms of whether there is any relevance of, or rather, what is the diversity in terms of the genetic differences that we look at?
Thanks for your question. So first, maybe let's start from the German civil liability situation. I'm not a German lawyer, but I can point that so there is a specific piece of legislation ruling pharmaceutical products liability, and under that piece of legislation, basically you can try to prompt damages against manufacturer. There are special rules as to the burden of causation, especially, but still the threshold is very high. And reading, especially the trial, I also please what is clear to me is that the main argument is indeed first the proof of effectiveness in terms of trying to prove that there is an effect of manufacturing or design. And in this respect, for instance, the German law has a special disclosure tool. So I think that during the trial, at some point, the claimant can access to some information that are only known to the manufacturer, because those the manufacturer, of course, has no limit of the process to get the switcher product. But even so, in practice, it is extremely hard. And when the problem is not about the effectiveness of the vaccine, immunization is definitely the other main challenge. And that's actually the thing I've been describing, that there is a lot of case development. And it's really tricky.
Can I maybe it would be good to ask Bill the same question about in the Australian context, what are the barriers to somebody bringing a claim in negligence or some other civil claim?
I think as I understood, there were two parts to that question. One was whether there may be some deficiency in the vaccine rollout and testing by not getting a sufficiently broad genetic tool. So the numbers, as you've seen in Australia, without this outcomes, is very small. But Australia does have a pretty large genetic pool. And I haven't seen any published material that suggests that the reactions that are presented themselves, be it thrombocytopenia or the pericarditis, I mean, they are sometimes age-related and they're sometimes gender-related, but they don't appear to be race-related. You certainly can, under the Australian consumer law, if you're feeling extremely brave, bring litigation against the pharmaceutical manufacturer, such as a vaccine manufacturer. It's possible to do, but a number of those cases which have succeeded have been found limited, and sometimes the economic outcome is a little bit hard to justify the most reason. Classic example, I suppose, has been the Carroll O'Dea litigation. Yeah, it's a whole decision. I think it would be difficult in Australia to succeed in an argument like that. I think it was clear from the outset that the vaccines were developed in a relatively short space of time. That was made clear. That was arrangements, contractual arrangements with the governments to make clear that those limitations would exist. And there were some private arrangements between the government and manufacturers to forward provide vendors, which I haven't seen. But I don't think, that's not correctly, I don't think there would be any serious attempts at litigation with manufacturers.
So
Melbourne from the law. It was fantastic. It's really interesting to hear about what you're doing, especially because it will be something covering many back long time. Australia is only on here. I thought it was interesting, Bill, that you said it was seemingly under pressure from the state or acknowledging there might be pressure to protect that. Yeah. What was it? Maybe more general. I mean, I can see that being part of it, but it also to increase the uptake of getting vaccinated so that one could say if there were an adverse reaction, at least we have this or will have one.
Yes, I don't think there's any doubt that when the announcement came, it was framed as a benefit to the general public, to encourage people to take up vaccines even if they're not in small groups. That I wasn't meaning to suggest otherwise. I just noticed that the first discussion that came about was some fear by doctors that they might be sued. And I think the lobbying efforts of the doctors were very helpful in making the political, the politicians turn around and want to take a broader approach. I'm not sure whether they ever actually did develop a successful scheme which stopped the doctors from being sued, or identified the doctors that they asked that I was talked about, but I'm not sure whether that did.
That was sorry, it's a bit of a follow-up. I can't remember, I looked at this and I remember thinking, possible fine because the name of it is so bizarre because the policy is the soccer.
Sure, yeah.
So they haven't provided a community to.
If they have commercially responsible arrangements, which I haven't, it hasn't been shared with them.
Thank you. Can I share a question from Professor Margie Danchen? So Professor Danchen is head of the vaccine uptake group at the Royal Children's Hospital. And Margie's asked both of you about clarification about whether the schemes depend on permanent injuries. So I think Irene, she said the Italian scheme only covers permanent vaccine injury, but does the German scheme cover all injuries? Because some are serious, but not necessarily permanent. Yeah.
Very good question. And one of the points in the German scheme that's wording of the law doesn't really make it permanent benefits, it's about the health and economic resiliency that goes beyond the individual extent of the action, which does not necessarily mean as not necessarily permanent. Whereas the Italian system is
permanent, yeah. And how does it define what a permanent vaccine injury is?
I'd say when there is an irreversible psychophysical damage. So that's the main requirement. Yeah, yeah. And Bill, in the Australian context?
Not in the Australian scheme, etc.
Good. Yes, thank you.
Curious, and as far as I know that the Pfizer, Moderna, they require the speaker, in this case, the government, take over the liability, basically, for during in the pandemic conditions, the manufacturer shall have the product liability, but during the COVID-19, they require the government and that's why the whole system is available. Whether in Australia, the manufacturer also requires the government to take over the liability.
The short answer is I'm not sure. Certainly, it is still possible to bring a claim against, for example, an individual medical practitioner. So, say, for example, someone went to the medical practitioner, they were given an initial dose, they had an adverse reaction, and that was a contraindication, so that they should never have been given a second dose. And the medical practitioner negligently does. You can still sue the medical practitioner. There's no barrier to that. But exactly what contractual arrangements background in the event that someone was to bring a case against AstraZeneca, I just never seen that. The other thing, of course, which sort of ties into your question is what happens if this scheme doesn't take in. And I must admit, I may be wrong about this, I may be naive about this, but I can't imagine the government ending this scheme yet. It just seems to me premature to be bringing this scheme to an end at a time when people are still being encouraged to get booster vaccination. So I would have thought that I would spend probably a bit longer and that there could be some way to encourage them to do that. If not in exactly the same form, then some other similar.
I'll just share a comment from someone online who says that their pain point has been for retired pensioners who experienced pain and suffering, however, could not claim because they didn't reach the initial threshold of incurred expenses of $1,000.
Yeah, I understood that there was some degree of latitude with the threshold. And if the pensioner had a significant, on that scale between 0 and 100, if they had a significant
can understand the pension is probably out of cost.
Yeah.
I think that's something that it could well be at that.
Yeah.
But I haven't heard it said that they couldn't even get out of it.
For the pain and suffering.
Yeah, I'd be interested if that person send the message I'd like to.
Thank you. And just one final comment from somebody online about what you think might be the role of the state and territory governments in dealing with these issues going forward, given that this was a Commonwealth scheme, but the states were highly involved in the pandemic response and the vaccine rollout.
Sure. Now, my understanding is that probably can't. I would be very surprised if one Parliament involved in negotiation, as the Commonwealth and the states always do, without who should pay for it. And there is treatment being provided in the state hospital system. But beyond that,
Okay, well, we're nearly at 2, so I will bring us to a close. I'd like to thank both Irene and Bill for fantastic presentations. I'd like to thank everyone for joining. And just in the last minute, I'd just like to encourage if we have any general practitioners in the room or online, or if you have family or colleagues who are general practitioners, I'm part of a project called Vax for Youth, where we're looking at consent issues for young people who were seeking the COVID vaccine but without parental consent. And we're running a survey for general practitioners. So there's a QR code there, and you can also find the Vax for Youth project online. So if you would care to either complete the survey if you're eligible, or pass it on, we'd be very grateful, because this is part of a research project we're running between Melbourne Law School and the Royal Children's Hospital. So thank you very much for coming today. It's great to see everybody. Thank you.